Good evening. My name is Lisa Ellsworth. I am the chair of the Woodburn Planning Commission. Welcome to this April 10th meeting of the Woodburn Planning Commission. And I get a roll call, please.
Commissioner May.
Present.
Okay, I moved over here if you're looking for me on the other side. Commissioner Berlin.
Here.
Vice Chair Hernandez Mejia.
Here.
Commissioner Lassen, I saw, but I'm not hearing him right now. I'll keep looking for him. Commissioner Bartel.
Here.
Chair Ellsworth.
Here. All right. Would you join me in the flag salute, please? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, it looks like we have minutes in our packets. Has everyone had a chance to review the minutes?
Yes.
Are there any corrections, additions, changes? Seeing none, I would entertain a motion to approve the minutes.
I move that we accept the minutes of March 27, 2025 as shown.
I'll second.
Okay, we have a motion and a second. All in favor? Aye.
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 Just for the record, I'll abstain since I wasn't here on that one.
Okay, so we have one abstention. It looks like we've got one.
Four or five affirmatives, right? 1, 2, 3, 4 affirmatives. Thank you.
And four. Okay, do we have any business from the audience that is not otherwise on the agenda later on this evening? So does anyone want to talk about anything that is not already on the agenda? Okay, seeing none. Do we have any communications from staff?
No, Madam Chair.
Okay, thank you. So it looks like tonight we have one quasi-judicial public hearing scheduled. The purpose of the hearing is to ensure that all interested parties can offer relevant testimony to the commission in a timely and orderly manner. Because this is a quasi-judicial hearing, commissioners should maintain an open mind and not make any decisions until after the hearing is closed and all evidence has been presented at the hearing and the hearing has been and is considered. Okay. So with that, I would like to open this public hearing on annexation 24-02. This annexation is approximately 32.2 acres to be rezoned a residential single family with a subdivision in Mill Creek 2, which is 130 lots proposed by Icon Construction and Development. So before we go further, are there any ex parte contacts that need to be disclosed? Any conversations with the applicant or any other parties? No. Has anyone made any site visits?
I've driven around there, but
Okay.
never left the car or contacted anybody.
And are there any conflicts of interest or biases that would preclude you from making a unbiased or impartial decision?
No.
I don't see any online either. So does anyone have any challenges to any of the commissioners on the declarations that we just listened to? Okay. So with that, can we go ahead and have the hearing statement read, please?
You may, Madam Chair. Both Oregon law and the Woodburn Development Ordinance govern evidentiary quasi-judicial land use hearings and require that at the commencement of the hearing, a statement be read to all persons in attendance. The applicable substantive criteria for this land use decision are listed in the staff report and are as follows. This is Transportation System Plan, or TSP, figures 2 and 6. TSP Project R29 South Arterial, and then the Woodburn Development Ordinance, WDO, sections 1.02, 1.03, 1.05, 2.01, 2.02, 3.01, 3.02, 3.05, 3.04, 3.08, 4.01, 4.02, 5.03.10, 5.04.01, and 5.04.04. The hearing will proceed in the following general order: staff report, applicant's presentations, testimony in favor of the application, testimony in opposition to the application, rebuttal, closure of the record, deliberation, and decision. All testimony, arguments, and evidence must be directed towards the applicable substantive criteria just stated or other criteria in a plan or land use regulation which the person believes to apply to the decision. Failure to raise an issue accompanied by statements or evidence sufficient to afford the decision maker and the parties the opportunity to respond to the issue precludes appeal to the Oregon Land Use Board of Appeals on that issue. Failure of the applicant to raise a constitutional or other issue relating to proposed conditions of approval with sufficient specificity to allow the local government to respond to the issue precludes an action for damages in circuit court. Any party wanting a continuance or to keep the record open must make that request while the record is still open and prior to closure of the hearing.
Thank you. I want to note that I see Commissioner Lassen has joined us online. Let the record reflect that. Thank you.
Madam Chair, could I ask Commissioner Lassen to clarify if he's had any ex parte contacts
Oh, absolutely.
or let's see, conflicts of interest or site visits? You had your mute on there, Commissioner Lassen, but we see you saying no.
Colin, are you able to? There you go.
Okay. Yeah.
Thank you.
No, no export. No, I'm good shape. Haven't been see
Thank you.
anybody.
Okay. Does anyone want to raise any concerns about that declaration? Seeing none, may we have the staff report?
Good evening, Madam Chair, members of the commission and the audience. My name is Colin Cortez. I'm senior planner with the city of Woodburn, and I will do a slide presentation of the agenda item. The Schwenke Vezey Annexation and the Mill Creek 2 subdivision. What's before the commission is an application package for annexation, preliminary subdivision, and a zone change to apply city zoning to county property. The role of the commission is to make a recommendation on this package. And the reason being that because it involves an annexation, it gets to be a city council decision. And so the role of the commission is to make a recommendation to council on how to act on the package. As a formality, the staff reports, attachments, and ignore an addendum. There's no addendum to this item. They're all part of the record. And I will add that there is only one piece of testimony. No one from the public testified, but we did receive a letter from the applicant's attorney today. We made it available as copies on the dais, as well as putting it online on the Weaning webpage. And I'll cover the substance of it in later slides. High-level overview is that the annexation is a little more than 32 acres and includes some adjacent right-of-way of South Boones Ferry Road, along which the property is located. And it's also adjacent to the south side of the Boones Crossing subdivision. The proposed subdivision would be 130 lots. More specifically about where's the site, you can see on this vicinity map showing property boundaries and streets in black and white, and parks are in green for orientation. This reddish area in the center is City Hall, and you can see south is the subject territory colored in purple. On the left is an excerpt of the zoning map. The property is blank because at the moment it's in the county, but upon annexation and zone change, it would have the same zoning as the vicinity nearby, the yellow, which is the residential single-family zone. And on the right, outlined in purple, you see the subject property, which basically was a farm. And this is a close-up of the property. To the north, you see houses in Boones Crossing. On the left, you see an open field that is a combination of what would be Boones Crossing Phase 6. And this parcel to the northeast of it is a city park that's supposed to be improved starting sometime this summer. South Boones Ferry Road is on the left to the west. And then towards the east, a couple hundred feet beyond the property is Brown Street. This is on the ground view, consisting existing conditions. This is looking from Boones Ferry Road, southeast onto the property. And these are taken from closer to Boones Crossing, standing on what is a segment of the South Arterial, also known as East Traverse Road. On the left is more or less near the end of Irish Street, looking east along the north boundary of the territory. And on the right is looking west towards Boones Ferry Road. As far as the development itself, the subdivision, on the left you see the aerial view, on the right compared with the preliminary subdivision plan, with the proposed rights of way within the property colored gray. And as you can see, the plan is quite logical, pretty straightforward. And this is a close-up of the plan showing the 130 lots, plus a few tracks for private alleys, a water quality facility or stormwater detention tract, and also a number of tracks for off-street bicycle pedestrian paths. Reiterating the summary from the staff report, the result from staff working with the developer is that approval and development would lead to street improvements, including street trees. There would be street stubs to allow a logical network of streets for future developments to extend from this property. There are common area improvements, particularly bicycle pedestrian paths I just mentioned. There'll be some traffic calming, some of which you've seen in other existing developments like Smith Creek, for example, and we'll see in Marion Point subdivision, where some of the crosswalks are built as concrete amid the asphalt to help signal to drivers that there is in fact a crosswalk there. And there's also a few trees on the site, even though it was a farm. And the proposal provided enough information to show that trees qualified for removal. And for those that had to be saved, the applicant will be paying the applicable fees for the fee schedule. There were some additional trees that would have been required to be saved, but I believe you've all heard of the ash beetle. And so for that reason, the ash trees are basically not of significance. As far as the process, there's a part of the staff report that had something called analyses and findings that you've seen before for other projects that compare what's proposed with what various city regulations are. Going to the annexation itself, it's pretty straightforward. The basic requirement is that the subject property be in the urban growth boundary and adjacent to the city limits, which it is. And the proposal otherwise meets the general criteria for annexation. And so staff is recommending, the Planning Commission recommend to the council approval of this annexation. As far as the preliminary subdivision, it's a standard subdivision. There's nothing else with it. It's not a planned unit development. There's no street adjustment application, no variance. It's for 130 lots. There are the tracks I mentioned for the private alleys and the bicycle pedestrian paths, and staff is recommending approval with conditions. I mentioned the applicant's attorney had submitted a letter with 3 topics. The first one that was mentioned was an objection to one of the technical items in attachment 102A, which is a series of comments from the Public Works Department. That comment was a rewording and rephrasing of the requirement in the development ordinance that public improvements generally had to be constructed before subdivision plats recorded. And staff basically is willing to strike that because it's unnecessarily rephrased and redundant of the code. Moving on to the other 2 more substantive items. This is a summary of the 2 conditions in question in front of you. One of them on the left refers to the South Arterial, also known as East Traverse Road. The condition includes a part requiring a median. So summarizing what's on the slide, the commission might remember that for the Mill Creek Meadow subdivision, a couple hundred feet to the east, when that went through the subdivision process back in 2022, that was conditioned to have a median, and there'll be a slide about that a little farther on. The median was mentioned following the pre-application conference for this in the follow-up notes to the applicant. And in response to the applicant's letter asking if the Public Works Director had been aware of it, Staff is confirming that the Public Works Director was well aware of the median and agreed to the concept, and that's why it's in the condition of approval. And we got verbal confirmation of that from Curtis Stolt just today. And then staff had provided a draft of the condition with this median requirement to the applicant about a week before the staff report went out. Another condition, the one seen on the right, describes for certain narrow lots within the subdivision that the driveway aprons be shared between given pairs of lots. And there'll be additional slides illustrating and describing exactly what that means. The image here shows of the 130 lots, only a small fraction of those are subject to the condition. So describing what a joint or shared driveway is more, it's essentially a driveway that serves two properties but has one apron, basically one ramp or slope within the right-of-way where the curb is on the street. The genesis from this is that it applies a code section relating to shared driveways in order to make sure that the minimum street tree requirement can feasibly be met for this proposal. The reason behind that is the lots that you saw highlighted in green are about 50 to 51 feet wide. And with the maximum driveway width being 16 feet typically, that will eat very much into the landscape strip along the street, as well as the ability to actually site the required number of street trees. And that was a concern, the ability of the proposal to meet that standard. And so staff applied a condition to make sure that shared driveways would help the development achieve the minimum number of street trees. And I stress this that because for developments generally, streets carry a lot of functions and things, and it's sometimes difficult to site street trees as they are because there are other needs for streetlights, for example, for cable boxes, for laterals for potable water from the street to houses, things that take up room under the ground or on the ground. And so it can be sometimes very difficult to site a street tree after all that other infrastructure is accounted for. And having driveways be more constrained helps make sure that we do get street trees. I had drawn up for this slide presentation a schematic diagram to try and get the concept across. So this is a plan view of two imaginary lots, about 51 feet wide each. The squarish areas indicate a typical driveway parking area in front of what would be a two-car garage as an assumption. Typical setup is that each lot has its own driveway, maximum 16 feet. And there's the assumption that the houses that the parking pads are in front of are the minimum 5-foot setback from the sides, and that the side of the garage protrudes about 2 feet side of the driveway. And as you can see, between the lots and between the driveways, the aprons on the street, there's some leftover room. In many cases, it may not quite be as wide as this, and it may not be wide enough for a street tree, especially if there's something else already planned for there, like a light pole or a fire hydrant, for example, or a water line under the ground. And on the right, you see a potential example result of what the condition could result in. It assumes the driveway on the private property side is about 18 feet deep. It could very well be deeper. 18 feet is just the minimum for the zoning ordinance. And you can see the idea is that in the right-of-way at the apron, the condition limits the total width of 32 feet. So you bring the 16 feet together, and you have more room on either side, longer stretches of planter strip that are more likely to fit more street trees. And it also shows that vehicles still have the ability to park on a driveway and maneuver in and out of properties. And as you saw before, this is a larger image showing that of all the 130 lots, the condition only applies to most and not all of the lots within the green groupings. Those lots, as you can kind of tell from the image, are narrower compared to most of the lots in the subdivision. Moving on to the other condition I mentioned, this is the one about the median. The genesis of this one is that this is the standard drawing in the development ordinance of the class of road that East Traverse Road would be, a minor arterial. So you can see the typical elements on the surface, street trees, sidewalk, and also that you see not only a center left turn lane, but also a median. And based on discussions with legal counsel, the understanding is that what you see in the image is the standard for this class of street. As far as the specifics of the median for the property, what you see on the screen is a precedent for the Mill Creek Meadow subdivision from 2022. The status of it is that it's going through civil engineering review, or rather, I'm sorry, it did, and the civil plans have been approved and issued by the Public Works Department. So the median's not built yet, but this is the drawing which would be used to build the median in that project. That project was required to have the median with a condition very similarly worded to what's proposed for this development, Mill Creek 2. And you see it reflected in the drawings. So as I mentioned, the example here is going to be nearby. The applicant and developer for that subdivision is the same as for this one we're reviewing tonight. Public Works and in concert with other agencies like the Woodburn Fire District have reviewed and accounted for the necessary need for fire trucks to get around. And in short, this is the closest example of what a median would look like in Mill Creek 2. I'll also show some photos of what it would look like. This is an example from Sherwood, Langer Farms Parkway. It's similar in that it's a one lane in each direction. And then you see the median. On the left, the continuous portion, and on the right, you see that where there's some sort of turning maneuver anticipated, there's a left turn pocket. And so the median tapers in and out of existence accordingly. This is another one from a much more heavily trafficked road in Wilsonville, Wilsonville Road. Similar setup, one road in each direction. And you see, again, the median. And then by comparison, a local example on the left of a road that is 2 lanes with the center left turn lane is Stacy Allison Way, which is what's shown on the left. And on the right, you see Wilsonville Road, which gives you an idea of the difference in terms of the feeling and expanse of asphalt. So with that, staff is certainly available to answer follow-up questions following the applicant's introduction and any presentation the applicant might have. And I'll take any immediate questions I might be able to answer right off the bat.
Is that the plan for the entire stretch once Traverse Road gets built out?
No, I will go back to another slide to show the extent of it. So on the left image, this area here is the road, and those green bars indicate where the medians would be. The reason there's not one towards the left is there's an approval for Boones Crossing 6 to be built, and that project already has approved street improvement plans, drawings, and so staff didn't want to complicate the situation to the west because that road might be finished by another developer. So the median is just about 1/3 of the total north frontage of the property, and it'd be 2 distinct segments.
And so the opening is, or the break in the median, as it were, with the turn lanes line up with actual roads as opposed to somebody crossing the road to pull into a driveway. Is that?
Yeah, let me go ahead to another image that'll illustrate what I mean.
Madam Chair,
Okay.
while he's pulling those up, can I remind everyone to keep the mics as close as they can to their chairs when they're speaking? Appreciate it.
Another reason the median is the extent it is in Boones Crossing, all of the streets that go down to the South Arterial aren't all through streets. Some of them are cut off with bollards for emergency fire only access. So the 5 streets you would see in drawings, only 2 of those are through streets. So on the left in red are the ones that are effectively dead end streets for passenger cars. Only Iris and Dahlia go through. And so for that reason, the median has a break, of course, at Iris Street and at Dahlia Street and on the east end of the project. But there's no need for other breaks because those streets don't actually go through for normal traffic.
part of my question was, we all know that until new projects come in, we're able to develop what is the full extent or plan of certain roads, and especially it being a minor arterial. Are those future plans also keeping in mind to try to make it look like a boulevard, except for that one strip that's already been approved?
I think the short answer to your question would be yes, because it goes back to this drawing. And it in turn is premised on our transportation system plan, which has a diagram that indicates for existing and future streets what class they are, like whether it's a major road or something smaller and more local. And for each of those classes, there's a corresponding drawing like this one in the development ordinance. And so based on this, and through Public Works Department, working with things like the fire district, getting down to nitty-gritty construction details determines like the exact extent of where the turn lane is and where the median is and how they change, and other elements of the road, like the exact specifications for the curb and the concrete, that sort of stuff.
Thank you.
Is all this traffic going to enter onto Settlemyre, Boones Ferry into Settlemyre?
Well, conceivably no, because there'd be two connections to Boones Crossing, Irish Street and Dahlia Street, as well as the connection to Boones Ferry. So at
But-
least 3 points.
Getting to the freeway or,
Well, yes, in that sense that unless some people choose to go through Boones Crossing to Brown Street to Cleveland, probably most would take Settlemyre, Boones Ferry.
And that probably goes without saying, of course, you would get to Parr Road before you'd be coming up further north, if you wanted to go west, coming north on Boones Ferry. And just so the terminology might be different. I think that's what one of the commissioner's questions had to do with. This is called Traverse East. Is it called East Traverse Road?
Yes.
Right. That's essentially the South Arterial that a lot of you are familiar with, that we have that run, that's planned in our TSP and has been there for at least 30 years to essentially be the sort of Southern Beltway loop, right? This is the big connection. This is the arterial that's trying to move as much traffic east to west without coming through the rest of the city. That's a big part of our TSP. It has been for years. These are the sections of it. The one section that was already built, is the one he's been talking about, which is the same developer actually, who's worked on it on the east side of Brown Street. This is sort of the next piece moving forward. We sort of get it as projects come in. If you're visualizing that, we don't get it all at once. It comes in as applicants come in.
For context, when was this image kind of introduced into what we consider the plan for the arterial? You
It
know,
was updated in 2019, I think.
Okay.
5 years ago, I
Yeah.
was involved with it. You were, few commissioners were.
thank you.
Do the commissioners online have any questions for staff?
Not at this
I'm-
time.
Yeah, I don't either this time. Thank you.
Okay, thank you. Do we have any other questions for staff before I invite the applicant up? Right, hearing none, I'd like to invite the applicant up. Please come up to the mic and give us your name and address for the record. Welcome.
Does it go green?
Just read.
Red.
Oh, okay. Sorry about that. Thank you very much, Chair Ellsworth and the Planning Commission. My name is Harlan Barrow. I'm with Icon Construction. We're based in West Lynn. And just wanted to quickly say thank you very much for tonight and the opportunity to present this project. We have worked collaboratively with both planning and public works staff on this so far, and we're looking forward to doing so going forward. Tonight, Hayden Wooten with Amira Design will present our information, and Garrett Stevenson is here to talk about his memo and the two issues that Colin brought up. And just real quickly with regard to this chair is thinking the median, There is one thing with the median, or a couple things that they'll point out in more detail, but the biggest thing for us is it conflicts with some existing utilities. And we talked about that at the meetings and in our response letter to the initial draft, which we really appreciated the opportunity to deal with. And secondly, just want to say that with regards to the shared driveways, because it is a limited number of lots, doing so isn't going to generate a whole lot more street trees. And because marketability with detached, well, not attached driveways is better for homeowners typically, we'd be willing to plant that many additional trees in yards and things to make up for it. So thank you very much. With that, I'll turn it over to Hayden.
Hello,
Hello.
I am Hayden Wooten with Mario Design. I'd like to thank Colin for his report. I don't have too much more to add, but I will touch on a few key points. The subdivision is going to create 130 lots. All of these lots conform with the RS zoning district, which will be applied to the property post-annexation. There are no natural features or hazards on the subject property, so wherever possible, we were able to continue the alignment of the existing streets and provide convenient access to utilities for future extensions. In a similar vein, anytime a lot fronts each traverse, which we are very much concerned about the safety of that road and the accessibility of it, we have provided alleys to ensure all of those lots will not take access. So using that, we will limit the amount of vehicles accessing that or backing up onto that street. I would also like to reiterate that this project has met all of the applicable criteria for an annexation, subdivision, and tree removal plan. And just going back to Colin, we really do appreciate the opportunity to review the conditions of approval prior to tonight. Staff has consistently been willing to discuss this project with us, whether it be impromptu meetings, random one-off phone calls, and it's resulted in a project that we like quite a bit as a team. It is just something we're hoping to iron out these last few conditions to create a truly ideal project for us as the applicant, and something we hope Woodburn finds acceptable as well. So with that, I will turn it over to Garrett for a discussion of these conditions.
There you go. You can either flip the switch all the time or press when you want to speak.
Got it. Okay. Thanks, Chris. Good evening, Chair Ellsworth, members of the commission. My name is Garrett Stevenson. I'm going to be doing this presentation one-handed, apparently, but I will try to flip the pages with the left hand. I want to make sure that we don't throw the baby out with the bathwater and realize that here we are, and as far as I know, there's not anybody with torches and pitchforks outside of this room ready to kill me when I walk out. So what this tells me is that this is a good project in pretty much all of the major respects. It's a relatively simple project. It's got a very predictable street layout. I know that's something that Colin likes to see. And we're of the same mind. I don't know how many conditions there are on this, but there are a huge number of conditions, as is typical with a subdivision. And I don't want to lose sight of the fact that we are of the same mind with the city at this point on all but two. So I don't want to overstate the level of disagreement with the city and the city staff right now, because that level is very, very small. These two conditions, however, are important to ICON for the reasons that you've just heard. And I was trying to ask quietly during the presentations about Mill Creek Meadows, that first subdivision that Colin mentioned. And what I understand that the difference is between that one and this one is that when that one was done, everybody knew that that median was going to go in, and the utilities that were put in that street were designed accordingly. And one of the major problems with this one in addition to what I said in my letter and what Icon and their design professionals have said in their letters, is that in this particular instance, all that stuff is already in the street. So you have manholes, the water and sewer lines are already there. And so that's what complicates primarily the issue of the median, in addition to our concerns about some of that turn movement. On the driveway issue, I assume that the goal is to get these homes sold, and the product that we're talking about with combined driveways, that's just highly, well, I'll say that regular driveways for these types of homes are by far more desirable than combined driveways. And what was interesting to me is that that driveway requirement came about because of a concern about there being sufficient street trees. But the only limitation on there being sufficient street trees are other public elements in the public right-of-way, like streetlights, sewer laterals, that sort of thing. So this is not a case where we're, say, sacrificing a tree to make a bigger house or something like that. This is a case where choices have to be made whenever you are building a street about where you're going to get your street trees in. And that's why most street tree requirements are a per lineal foot requirement. And most of the ones I've seen say you got to have a street tree every so many feet, and you have to kind of put those in where they can thrive. And they can't thrive right next to a telephone pole. They can't thrive on top of a data juncture. There's a number of things that street trees have to compete with in the public right of way. But I don't think the way to balance that choice is to make the homes less desirable and less saleable, because our goal is to build homes that will sell at a reasonable price and that will be desirable for the residents of the city. Now, I get the fun job of getting to talk about the law. And you heard some pretty good reasons from a planning standpoint why these particular features are desirable. Our concerns are not with the planning merits of a median. They're not with the planning merits of combined driveways. Our concerns are primarily with the engineering limitations on doing these things and the additional costs it will incur to my client as compared with the lower value of the homes that they're going to sell. So there's no question that if I were to open up a handbook on urban design, it would commend to you the things that Colin has talked about. That's not why I'm here to testify. I would never disagree with him on elements of urban design. I'm here to tell you that we have concerns both from an engineering cost standpoint. And the other thing I'm here to tell you is that I took a look at these conditions and I've got concerns that they cannot be legally imposed by the city. And there's a couple reasons for that. Most of those reasons have to do with what we call the clear and objective standards rule. And I didn't have much time to put this together, but in the case of the requirement for a median in the minor arterial, I want to make 2 points there. Number one, there's nothing in the transportation system plan, and I did review it, that says there should be a median at this location right here for this road. And when you look at WDC 3.01.c, it shows a schematic of a minor arterial, and Colin showed you that. But what we didn't see in the PowerPoint is the note underneath it. And it says specifically, note 3.01c, the illustrated median is conceptual, optional, and at the discretion of the Public Works Director. So when the city adopted this layout, it went to some degree of specificity to say, we want you to do all these things, except that the median here is not necessarily required. It's at the discretion of the Public Works Director. And it's that discretion, when it's applied to a straight subdivision, that makes this standard not clear and objective. In other words, there's case law saying that if you give the discretion to impose a certain thing without any criteria for doing so to a local government staff person, that standard is not clear and objective. And under ORS 197A, subsection 400, subsection 1, when you have a straight subdivision like this one, those types of regulations cannot be imposed by the city. Now, I would much rather talk about the planning and engineering merits of this, because I know that planning commissioners, last thing they want to hear is a lawyer telling them that they can't do something that they want to do, but that is my job as legal counsel for the applicant. Very similar situation is at hand with the regulations concerning the combined driveways. And in that case, the regulation that authorizes it basically says that the director may require that 2 or more dwellings across 2 or more lots within a partition subdivision or plan unit development to share driveways, for example, by requiring detached houses on adjoining lots to share a driveway along common lot line. That's the regulation that city staff is relying on to say, we're going to require combined driveways here. That has the same problem of ambiguity that the median requirement has. And so if it said all lots in a subdivision shall have combined driveways, we'd be having a different conversation. And if it said that a median is required along every inch of every arterial, we may be having a different discussion. But the case law on this is clear. It all comes out of a fairly old case, which is HBA Lane County v. Lane County. It's 41 Oregon Luba 370 2002. And what that case says is that if you're reviewing an application for the development of housing, and it is not a planned development or something where an applicant selects a discretionary pathway to approval, that all of the regulations that you're applying have to be clear and objective. And they actually looked at a few very much like these two. And what they concluded is because it just simply left to the city staff whether or not those things should be done, they could not be clear and objective regulations. So that's the legal basis for my arguments. But I think that the engineering reasons here sort of speak for themselves, at least in my view. And I encourage you to focus on what you heard from Hayden as well as from Harlan. And I appreciate your time. I appreciate staff's good work on this. We do have obviously a difference of opinion on 2 of the conditions, but we would still ask obviously that you approve the project. And of course, our only deviation is that we'd ask that you approve it without conditions SUB 3.C and SUB 6.B. So I'm happy to answer any questions, but unless you have any, I'm happy to sit down.
Hi, this is Deb Bartel, and I have a question. When you were discussing the first item that you disagree with, you're saying that it's a bit ambiguous, it's not a clear and objective regulation. I guess I would wonder why you consider that when it says that is at the discretion of the Public Works Director. Isn't that a pretty clear and objective option?
Well, luckily, I don't have to necessarily invent an answer to that, because that particular question was answered in 2002 in that Lane County case I mentioned. And there, because I wanted to make sure I was on solid grounds here, and I did look at some of the regulations that they found not to be clear and objective. And among those were regulations that basically said if the, and I'm paraphrasing here, I don't have it right in front of me, but among those regulations was essentially a variety of things that said if there is, if a city engineer or a city planning director finds that these circumstances are at hand, it's the discretion of the city engineer or city planning director to do X, Y, and Z. And in that case, the Home Buildings Association of Lane County said, well, we think all of these are not clear and objective. And if you want us to do these things, then you have to say, all right, where, do we need to do them or don't we? And under what criteria does a planning director or a city engineer make that determination? And LUBA agreed with them. And that case was not challenged to my knowledge at the Court of Appeals, and it remains good law. So that's my answer. I understand your impulse, and that seems to make some intuitive sense. However, LUBA found that when you leave it to that level of discretion, it wouldn't be clear and objective. And I think what LUBA was thinking about when it said that is that the whole idea of having clear and objective standards. And remember that these don't apply to all development of land, and they don't necessarily apply to all development of land for residential uses. But when you're taking a clear and objective pathway, like a straight subdivision, for example, which is what this is, the idea is that LUBA and the legislature wanted to give applicants absolute predictability about what they had to build. That was the reason for that. That's the reason for the clear and objective standard requirement. And when you have something in your code that basically says a planning director or city engineer or city public works director can decide at some point during the process, maybe even after the process, what's going to be required, the view was that that did not give the applicants for, at that time, needed housing, and now the applicants for housing generally, it didn't give them the predictability the legislature wanted to give them. So every single code and every single city that I've seen has stuff in their code like this. And it is not easy to write a code that accomplishes everything that a city wants to do in a clear and objective way. And it's not at all unique for Woodburn to have this stuff in their code. And this stuff is applicable to certain types of land development and is applicable to certain types of housing development, just not this type of housing development.
Okay, I have a question. I think having the option to put a median in by one of the city officials, we're concerned about the way it looks as well, not just that you're saving money. So, I mean, it looked more attractive with it, and why not?
Sorry, did you have
How
a
much-
question? That sounded like a statement.
Okay, how much did it add to each house?
I don't know. I mean, again, what I'm entrusted to do here is just explain our legal basis for what we're asking for.
Well, but it also says it's up to the discretion, so that's, you know, we have to decide on which one was correct. You're citing a case that was years ago.
Yeah, I understand. It's still the law, even though it was 2002. And I guess my point is not that we're asking that discretion to be used in one way or another. We're saying that the regulation that relies on that discretion cannot be applied.
And Chair Ellsworth, can I
Yeah.
Direct a question regarding this to Colin? I'm curious, or do I have to do that later?
Before you do, I would like to interject, but I will come back to you, I promise.
Okay.
I would actually like to turn to my city attorney, and not to be disrespectful, but as a planning commissioner, I need to rely on my city attorney's counsel and not necessarily take yours. You quoted a number of OARs. I don't have the OARs in front of me in order for me to read them and digest them myself. I appreciate your perspective, but I would be remiss if I accepted your perspective without conferring with our attorney. And a couple things I think could happen at this point. We could go for continuance and have the time to look up the OARs and get advice from our attorney. But at this point, I'd like to get a little bit of advice from our attorney on how best to proceed, because this is an area that is beyond the level of expertise with the people up here. And I respect both of the attorneys, but I would be remiss if I didn't turn to mine for advice.
Understandable, Madam Chair. Yeah, so I'm prepared to kind of provide the city's perspective on some of the things that Mr. Stevenson mentioned in his memo. We'll start with the things that we agree with for sure. So as mentioned earlier, that public works condition, we're going to strike that. We've already drafted up language to make sure that whatever motion you go with tonight, that'll be in there as being stricken. State land use laws have changed a little bit with regards to that condition, so it's based on some older language, and everybody's completely comfortable getting rid of that.
Great.
As for the median, so there's a couple of different things that I want to mention. In his memo, Mr. Stevenson discussed some fire safety concerns, and the city's happy to modify that condition to make clear that, of course, any median that's proposed will meet state fire regulations and standards. That's generally, implied, but we're happy to make that explicit in there. Let's see here. And then getting into and again, apologies for, getting into the legal weeds of things. So the contention that Mr. Stevenson makes with regards to the kind of subnote there under figure 301B, the illustrated median is conceptual, optional at the discretion of the Public Works Director. He is correct that state law is still good state law. Our standards do have to be clear and objective. And our argument is that the standard itself is in WDO 3.01.04B. I'll just read that. So all public streets under the jurisdiction of the city of Woodburn shall comply with the cross sections depicted in this section, unless the developer obtains approval for a street adjustment modification through PUD, zoning adjustment, or variance as the WDO allows them to be applicable. So our position on this is that is actually the clear and objective standard, that you shall comply with this cross section unless you're seeking a street adjustment or a variance. In this case, the applicant is not seeking a street adjustment or a variance. And if they were seeking a street adjustment or a variance, that's where that kind of discretionary language would come into play. I'd also note that if Mr. Stevenson's argument were taken to kind of its logical conclusion, that would basically mean that the city has no street standards because every one of our figures, sorry, 3 of our figures have that same note under them. So just our position is that the clear and objective standard there is actually in 3.01.04B. Just look and see if I'm missing anything. Mr. Kerr, do you have anything to add?
I don't think so. And just to reiterate, we've seen a lot of subdivisions, planned unit developments in the city. And of course, the state law is evolving a lot. And I just want to kind of point out what you heard our city attorney say and what their attorney is pointing out. The city will not apply any non-clear and objective standards, right? A discretionary standard to any, used to be called needed housing, it's pretty much all housing, such as this project, right? The opportunities for that are under planned unit developments. They can get into variances where there's more discretion. I think the issue here, is pretty cut and dry. I know I oversimplify things too much. It gets me in trouble occasionally. It's a question of whether or not you think that requirement is clear and objective.
Commissioner Bartel, I will give you the floor. Oh, pardon me. Are you?
I wasn't sure if I was excused yet, but I did want to mention one thing. Our intention is not to blow out of the water the city's street design standards at all. What we're talking about is not the cross section in writ large. What we're talking about is the median. And again, I think that note 301 sub C actually means something because it says here, and I'll just say it again, the illustrated median. So one part only of this cross section, in my view, is not clear and objective. One part, and that's the median. And it says that the illustrated median is conceptual, optional, and at the discretion of the Public Works Director. Now, if it's optional, I'm not sure why we would need to file for a variance of some kind not to include it. Point being is that the test we always use is that if 2 reasonable minds can differ on what the language means, it means it's not clear and objective. And I think that's what's going on in this case. I agree with your city attorney that the code points to these graphics as your general standard. And luckily we can take a look at this graphic and we know how wide the center line or the center lane has to be, how wide the travel lanes need to be, sidewalks and so on. The only thing that this graphic is not certain about is whether there's going to be a median there. That's why we think it's not clear and objective. And so with that, I'll go ahead and conclude.
Okay. And don't go anywhere because we may have questions for you.
Sure thing. But again, I don't want to lose sight that we are within 98% of agreement on all of the issues with the city staff. So I appreciate your time.
I am keeping that well inside.
Thank
Believe
you.
me. I deal with OERs daily in my work. So, Commissioner Bartel, I cut you off, but I'd like to give you back the floor. Thank
And
you.
actually, what I wanted to ask Colin was if we'd had a chance to check with the city attorney to see what their take was on the information they were offering up, because I think even after both sides were very helpful, but even, I mean, I have my own thoughts. At this point, we can talk about it when it's time for deliberation, but both discussions were helpful to me.
And I did have a question for the gentleman in the plaid shirt. I apologize for not remembering your name.
Yes, how can I help?
So at one point you talked about the access design and it shows, so here's my concern. You talked about access to the arterials and that there wouldn't be issues. Do you have a picture or some kind of diagram that shows us how traffic would flow without the median? You said you didn't think that the median was necessary because of the way you've designed the subdivision.
Yes, so when I discussed access on East Traverse Road, I was talking specifically about the lots that have frontage on that street, that it was our intention to remove driveway access by providing the alleys. On, I believe it might be the last page of Garrett Stevenson's letter, an exhibit was put together illustrating how vehicles would move around the median. What we found was that it was a lot of very sharp turns. For the bulk of traffic exiting the subdivision, as Colin noted in his presentation tonight, it is primarily Iris and Dahlia. Those are the two primary exits in and out. And by limiting the lots with frontage on Traverse to alley loaded, we ensure all vehicle traffic moves through those local streets.
Thank you. That helps me visualize what we're talking about. And you
I
guys
think
live
the
and
only-
breathe this.
I think the only piece that the illustration that's included, I think is a little inaccurate, is it has entrances and exits from Sunflower and Daylily. And I believe Colin said that the only entrances and exits to onto East Traverse were going to be Dahlia and Iris. The others would have blocks, correct? They'd be blocked off except for fire access?
Yes, and we wanted to show what it would mean for an emergency vehicle to access those streets, given they are of some significant length, and it would be quicker for an emergency vehicle to use the closer access points than to navigate through the subdivision.
Understood. Thank you.
Do we have any other questions for the applicant?
Just clarifying on the alleyways, all the entrances or in and out of the houses or the homes that are right on there on Traverse, they're gonna be through the alleyway, not through the Traverse, correct?
Yes, all vehicle access would be provided with the alleys.
Thank you.
Any other questions?
Does anyone have any questions related to the driveway for the applicant?
I think the only thing would be, did we get input from fire basically saying that what we had is approved by them or similar, are they in agreement with the applicant?
Because there's an annexation, included in the packet was what's called a service provider letter. For example, from the school district and public works department, and there's one from the fire district, but it has very short boilerplate language, so it's not explicit in this particular point. But I do stress that in terms of the standards themselves, those cross sections for streets incorporate the needs of the fire code. And of course, by the time we get to building permit, we closely involve the fire marshal in particular before we issue approvals. So we're in touch at every stage.
Did any of the commissioners have questions about the shared driveway before we move forward?
With the shared driveway, You know, all of these new subdivisions have no space. And it looks like a used car lot when you drive by. I'm sorry, that's my impression. And with a shared driveway, what happens with the cars? People use their garages as storage. They don't put their cars in there. So what happens with the shared driveway? Anybody?
I mean, I'll speak to that and say there's no change to the quantity of parking. So there's a minimum parking requirement for the property and nothing about the condition affects the developer providing parking on the property for dwellings. The condition is focused on the apron, the access point that's in the right of way, the concrete ramp. And it requires basically fusing two for two lots to be one apron. And I'll stress that besides saving street trees, the advantage is that in terms of public on-street parking, having the shared aprons creates longer stretches next to the planter strip for more spaces for people to park publicly.
And two cars parked parallel?
Colin, you have a conceptual design that maybe you could pull up, I think that would be helpful.
I saw that one, but I couldn't really tell.
Yeah, Colin, I think seeing the design should help, but you know, it's rough, but the general idea is that the condition, as Colin said, is mostly refers to the apron, so coming directly off of the road there, and then the actual driveways themselves then kind of branch from that apron to each property.
So it would be tandem parking. Is each garage two cars or one car?
We don't know staff and we don't need to know for the subdivision. As you know from state law, the dwellings could be the form of houses or duplexes or triplexes, townhouses. So the image you see on the screen is assumes detached houses just for sake of simplicity. So it also assumes two-car garages. So like 20-foot wide swath of pavement on the private property side. It shows the typical condition where each lot has its own driveway. And you'll notice that between driveways, there's probably not room for a street tree in most cases and no room to park. Whereas compared with the next image, the shared driveway, you will see on the right side that there's more distance between driveways that are fused together. And so you might be able to fit in an extra vehicle on the street for public parking at least. It doesn't change the private parking, but it helps with public parking.
Applicant stated that there's a decrease in value. Do you have any data on that?
Harlan, do we have any?
Okay.
Data with me, read on. But if you, Colin, if you could put that back up for a second. Generally speaking, people like to have their driveway, and that circumstance, you'd have, I mean, for one thing, you'd have the potential that people could back up into each other because they're angled. And even if you make them not angled and put them together so that they're basically on the lot line, you're still sharing because it's a shared driveway, and you have maintenance circumstances where people drive onto the other side. And I mean, it's just not common, and it therefore is less desirable. There's also a problem with shared driveways like this because typically, as we've talked about, the need to try and find and put utilities in ways that don't conflict with street trees and street lights and things. Typically, you run your water meters and other things right near the property line because you know that you have a setback from that line for the building. And most jurisdictions don't like you to put water meters in driveways and things like that. So there's that practical issue as well.
Couldn't you do a few less houses so you have more room? See, that's never.
Certainly could, but we're putting the number of lots that code allows. If I could just add one more thing about the median, I know you kind of have moved on, but the utility conflicts that we talked about that are different than at Mill Creek Meadows have to do with manholes for sewer that are already there. And the median would go over where those manholes are, and you can't jog around it. So if the medians were to be there, those manhole structures would have to be raised up so that you could access them. And they would be over the line that if it ever needed to be maintained, the median and whatever trees had grown in it and stuff would have to be removed to work on that line. The lines are already there. So that's the real difference, I think, as Garrett mentioned, between Mill Creek Meadows and Mill Creek 2, is that these are already here. And when we designed Mill Creek Meadows, we didn't do that. We offset it from what's normal code and required in terms of location. And like I said, with regard to even both the median and the, because if you start shortening up the median to allow for the turning, you're not going to get a whole lot more trees in there. And because the shared driveways are limited to, a few lots, the number of additional trees that you would get out of it are not that great. And we'd be willing to, come up with a way of calculating what that would be and plant those additional trees in other places, in yards and things. So we just think both of those conditions should not be included in the approval. Thank you.
Okay. With that, I would like to invite anyone that wants to testify in favor of this project to come forward. Is there anybody in the audience that would like to speak in favor? Okay. Anyone in the audience that would like to speak in opposition? Is there anyone that would like to speak in opposition of this project? Okay, seeing none, there's no reason for a rebuttal. So with that, before I close the public hearing, I'm going to ask our city attorney question. But he's not looking at me. Is there any reason you can think that we should not close this hearing to further look at any of the OAR, some of the legal statutes, anything else that you feel it would be in the city's best interest to review anything, or is there any reason you can come up with it? We would not want to close this hearing.
It's really going to be up to you, Madam Chair. If you, as a commission, feel that you need more time to review Mr. Stevenson's memo and to review a staff response, then you certainly have options to continue the hearing and leave the record open. You could close the hearing, close the record, but continue your deliberation until a later date. It's kind of depends on what the commission's comfort level is at this point with the information that's been provided and whether you feel that you can make a decision based on the information that you have.
Thank you. So having heard counsel from our council, does anyone feel a need to leave this open? Are you ready to deliberate?
I have a question for Colin regarding the manholes that are already, or the line that's already there.
Okay,
And if there is a plan
Uh,
for that already,
Thank you, Commissioner. So I wanted to say that the condition for the median is generally and lightly worded because we are not civil engineers. It covers basically minimum extent, requiring a number of trees, and even allows for a great degree of pavement within the curbing to account for infrastructure. It doesn't specify exactly where every individual tree goes and that sort of thing. So when it comes to existing manholes, the condition would allow, for example, just to have some pavement around existing manholes and have it slope down to the manhole covers. That would be allowed by the condition. And I imagine that Public Works could imagine a number of other physical solutions that allow manholes to remain in places they are, but the median to be around them. So. Yeah, basically, I'm saying I think the manhole issue isn't really an issue, and I'm quite sure Public Works would agree on that.
yeah, before we close the record?
Madam Chair, just if I could just add one thing.
Absolutely.
Just a request from the city that if you were to decide that you wanted to close the public hearing, but to leave the record, close the public hearing, we'd request that you do leave the record open so that we have the opportunity to provide a written response to Mr. Stevenson's memo. So far, you've only gotten an oral response for us.
Your suggestion is that we close the hearing, but leave the record open to allow for written response.
If
Would we?
If you are inclined not to make a decision tonight, then the city's request would be that you close the public hearing, but leave the record open for additional testimony.
Okay.
And our suggestion would be perhaps 7 days for additional testimony if there's any from the applicant, and then 14 days for the city to provide response to any additional testimony that they add, plus our formal response to that memorandum. That would be our suggestion if that's something that you are interested in.
And
So this is the part where I just need to interject briefly. Under ORS 197-797, if we're going to have a back and forth about a question of law, and if the city and we don't agree, we'd ask that we be given our right for final written argument, which is allowed to us. And typically what that means is, because I don't, frankly, I don't have anything more to add on our arguments that would come in during a first open record period. So if you, just to sort of cut out some of the fat from that open record period, what I'd recommend is, if it was agreeable to the city staff, is if you were to continue it, and again, we're not requesting that you do. In fact, we prefer that you deliberate and make a decision tonight, because this does go to city council ultimately. That's my understanding. Am I right, Chris?
You're
Okay.
correct. It's an annexation.
Yeah.
So
So that, I mean, what I would probably request, and I haven't talked to Harlan about this, but I'm assuming it's okay, is that you guys go ahead and deliberate tonight. And to the extent that the question of law is still at issue, I mean, I'm sure we would take that up with the city council. However, if you decide to leave the record open, what we'd ask is leave it open for a week for city staff to provide a response to our legal points, which were not, frankly, that complex or detailed, and then give us final written argument, because it's the initial evidentiary hearing and we're allowed to have that.
just as an FYI for you and the other participants, I take your testimony and your counsel very seriously, and I want to make sure that we are considering everything that we need to consider. I don't take this position lightly or the work that we do lightly. So by asking these questions, especially of our attorney, at that, I want you to recognize that my complete intent is to make sure that we are as fair and responsible in our deliberation as we can be.
Yeah, and Chair Ellsworth, I thought nothing except that. I think you guys have held a great hearing, and I appreciate your attention and the good questions.
So thank you. Do any of the commissioners think we should close the hearing and leave the testimony open? Are we ready to deliberate? I would look to my fellow commissioners to help with that decision. It's not mine alone. I'm ready to deliberate.
That's starting deliberation in that case.
Yeah. So deliberation.
That's,
I'm ready.
Commissioner, all right, with that, I will close the public hearing and we will begin deliberation. Thank you all. I will give Commissioner Berlin the floor.
You know, I'm all for visual as well as practical. And I want the median. I think it'll enhance the project. And as Colin said, that there's not that much to do about the manhole covers or, you know, so I would say I want those in.
Vice Chair Hernandez Mahia, you have a comment?
I think one of the ways, and I'm also thinking about this, is the future extension, which is why I was really asking, what are the plans for the rest of the road as we get to it? Because I do know it's a slow process to really build out. And for making the community not only visually appealing, but also the trees and being able to walk through and not burn, because then I even want to drive to the park just to hang out where there's trees. Makes no sense, right? But I do think of trying to and creating ways in which we're definitely making improvements to our city. At the same time, I was definitely hearing there being difficulties in the median because of any manholes and things like that. Sounds like it's solvable. At the same time, it also seems like there's still differing opinions there. I also appreciate the attorney coming up and saying, you know, we definitely want to just kind of keep moving on this. And so also in respect to that, and obviously there's still time in which they're able to definitely share and at the city council, wanting to also be respectful of where they're wanting to go with this. And while yes, we keep hanging on this point, I also want to say and give appreciation for every other point that was agreed upon, because I know that there's a lot that ends up going into this. Ultimately, I think I'm still leaning towards having both of the recommendations still go through. But I'm very much open to listening to the rest of the commissioners and where they're standing and what the arguments are.
Commissioner May.
yeah, I'm fairly new to this whole thing, right? So I am a little green on that, but I'm a little torn, especially when we start talking about the manhole covers a little bit, is almost, to me, it almost looks like we maybe missed it on the front go to say, maybe we shouldn't put these here this way, or at least put them in a different way. And now we're saying, now you need to go and rework the manhole covers, right, to make the meridian, right? So to me, I feel like that's a little hit, you know, on one side, but then I agree that if you look at a city and if this is going to be a major artery that people are driving all the time, it's like, this is as anything else would be, a representation of what your city looks like and the experience and feel of your city is. So yeah, I'm a little torn on that particular topic in particular. But I also, you know, if things are outlined in our code for a reason, that's what we try to adhere to and kind of follow as a standard. So yeah, I'm a little bit up in the air. I could definitely see both sides of this, but yeah, I'm gonna be leaning in, I think, just with my greenness, I guess, to the committee here, that I'll be listening to other members. Okay.
Commissioner Bartel.
Sure. I feel like the median issue is less of an issue. I think it can be resolved. I think Colin came up with a good thought. Just, you know, we could always have the manhole covers. There could be a barrier around them. I think a median doesn't have to be solid. It could be islands that have trees and then plenty of room for the rest, where it just like it shows here in the picture, there's kind of a tree in an island, and then there's just open street where the manhole covers and things could be, and to give more room for the emergency vehicles. So I'm inclined not to grant that request for to not impose that particular condition. I'm uncomfortable with the whole shared driveways concept, but not it doesn't feel as safe as having a straight driveway. But if they feel like they can do the shared driveways with still doing the trees and giving everybody as much room as they need, I just question the ability to have the right spaces to put the water access and things like that. And maybe it's just my own personal experience with having straight driveways rather than slanted driveways like that. But I just feel like it's when they're slanted and it would be so easy for somebody just to back into each other, or somebody to have a big old truck that hangs out halfway through the sidewalk that impinges on my side of the driveway. I don't know. I'm uncomfortable with that one. And I almost am inclined to grant their request to not require the shared driveways. But I think that the median, I think that is something that where the public works and the planners and the developers could come up with good solutions for that. So I'm not inclined to grant to dismiss that condition.
Thank you. Commissioner Lassen.
Yeah, listening to this going kind of back and forth, I'm really perfectly good with it. I understand what's happening. We've been through it before, years past and whatnot. So similar things like this, but I think it was very well presented. I see no reason to beat it to death anymore. And so I'm good with it. That's it.
Okay. I think the shared driveways are a bad idea. I'll be frank. I would rather see a better tree plan from the applicant. I also would not want to buy a house. I agree with you 100%. I would not want to share a driveway. If your truck hung and you're in the way and there was, that needed to be fixed, and I agree with the applicant 100% on that. I don't agree with the applicant when it comes to the median. I do believe that street, in order to maintain safety and the streamline and getting cars going straight, that the median will help calm traffic, which I believe is part of the reason that we would want a median there. I do believe that the city and our city public works should be able to work with the applicant to make a median that is feasible, that can work around the utilities. That's kind of where I am. I'm with Commissioner Mejia that what's gone before and what's coming after this really should match. But again, I would expect our city staff to ensure that the fire department can get in and out. That if we need to put a break because of utilities or manholes, that we can work with the applicant. That there's plenty of room for turn-ins. And I know that you're doing it on the one before that. That's where I am. Does anybody want to further deliberation?
I want to add
Go for it, Chris.
one point if I can, and that is on the shared driveway. My wife and I, we have a house in Woodburn, and we've been there about 15 years. We have a shared driveway. It's never been a problem. And I think it kind of is handy liking the neighbors. So it's, they look after our property, we look after theirs. At any rate, as far as a problem with the shared driveway, I don't have a problem with it.
Thank you for sharing that, Commissioner Lassen. I was because I didn't necessarily address the shared driveway in my if we didn't do it to where they're connected in the way that you showed, Colin, in that drawing, is there a way of being able to make sure at least maybe that they're kind of close together and it just has that enough space for potential utilities in the middle? And like that, there still is some kind of creation of, putting them about as close as possible so that there's hopefully more availability for street parking or other. And that's kind of where I'm thinking. I don't know if that would be already something expected.
I can speak to the development ordinance. So the regulation would be very light, and that the maximum width for a driveway would remain 16 feet. Could be less, especially if the housing product might happen to be 1-car garage instead of 2-car, for instance. And the only real restriction is typically because parking area has a setback of its own from a property line of 5 feet. Probably the driveways would each be about 5 feet from a side property line. Otherwise, there's not much restriction on where a driveway would be on the frontage.
So are the utilities in that V? You know, where the driveways go?
Oh, and the diagram you're referring to, could be.
No, I mean, you could just close it, right?
I suppose if a home builder wanted to, that possibly with additional pavement is what I think what you're describing. Yeah. The condition wouldn't require that.
Setback less, the houses would have to be close enough, and your garages would be, and again, I think it's would almost be attached. You're talking almost about very close to being a duplex. You know, closer, and most people are going to want more room between their garage and their neighbor. So if you had the straight driveway and a 5-foot setback, then your garage is here. You are like knocking on the neighbor's door.
But actually, it's the garage, not the house.
Yeah, but usually your garage is here, your house is right here, and you're going into your house from the garage.
Well, considering how some of them are houses and narrow spaces and lots that they are, that's
Right. Not 5 foot. You would be this far from your neighbor.
well, from the property line, and then they would be another.
Any other comments?
Madam Chair, if you don't mind, I was just, I want to make sure, I think I heard during the discussion or during the applicant's testimony, I thought I heard them say regarding this shared driveways. I want to come back to the code issue and the reason that staff specifically requested, aside from the other items that we talked about, you know, ancillary, everything, there's on-street parking, et cetera. For these skinny lots, because they're so narrow, the concern is that these individual driveways will take up so much space that they won't be able to meet the code standard of 1 tree for every 30 feet along essentially that block. I thought I heard a look for a nod that they were extremely confident they could do that and provide even more, right? That there would be enough room. And in our code,
What I heard was they would put trees in other locations to meet that standard.
that's correct. And frankly, our code actually has an allowance in there so that you can wiggle some of these trees around so that you don't, it's nice to have that uniform tree look, but again, there's often other utility issues that prohibit it, but our mantra is you'll provide the minimum cone number. If the commission were, I guess, extremely concerned or sympathetic to the applicant's concerns about having these shared driveways and what it means for housing, et cetera, on these small lots, I'm going to throw out as a potential recommendation for you is to not require the shared lots, but require them to provide a little bit more trees in there to make sure that we get them plus more, because that is a concern. Our concern was based on the code requirement. The code requirement's 1 for 30. You had a condition that said you didn't need to share driveways on those lots anymore, but on those 3 blocks, you provide 1 tree for every 25 linear feet. That would ensure more trees getting planted in there that they were confident they could do. Again, they can wiggle them around and move them, but that would be on them.
It sounds much more comfortable to me than shared driveways.
Just a suggestion.
These lots are small enough already. Having a shared driveway is going to make them appear even smaller. If they can do the trees in another way, I say we let them do it, but we require it. We make that recommendation. I guess it's not a requirement since we're not making a decision, but that would be a good recommendation to make.
And I can integrate that into a motion if that's something that the
Yeah, that
commission
would be
is.
nice if you could do that.
Yes.
Um, I have a sense that most of the commissioners are not necessarily in favor of the shared driveway, the angled driveways, but that ensuring that we get the tree coverage that we're looking for is more important. Yeah.
Yes.
Okay. So if you could help draft the right language for that part.
I can, I think I have most of it here. So if you're ready for a draft motion,
We'll keep that part. Are we ready to move forward with our voting with respect to the median, or do we need to deliberate further?
I feel comfortable with where I'm
Are
at.
you, Commissioner Lassen and Commissioner Bartel, are you comfortable voting one way or another with
Yes.
respect to the median?
Yes.
Okay, Commissioner May?
I think so.
Okay. So
Yes, yes, so now I got it unmuted. Okay.
okay, thank you. So is there anyone at the dais that is interested in making a motion? And if so, I would ask Chris to give them language that they could tailor to the motion they want to make.
I'm happy to read it if somebody could put it up on the screen.
Colin, can you type it as I state it so we can make sure that we get it crystal clear?
Yes, give me a moment.
With apologies for the fact that it's slightly inefficient. We always like to make sure it's as clear as possible.
And as he's pulling that up and preparing, just a reminder, what you're providing is a recommendation.
Yes.
And that's how that will be carried forward to the city council with your recommendation. Okay? As well as everything else that happened here.
They
We'll
will
pass the
have
whole
their-
record as well as the testimony, everything else that came in. And that's important. And that's for their consideration for them to take forward. So I only say that because it's usually you're making a final decision on a lot of these quasi judicial matters where every single preposition in your condition that you write is critically important because that's how it's taken down. This is a recommendation. So I'm just letting you know, it may be massaged and smoothed over by the city council.
Absolutely.
So with that, Colin, if you could go up to motion to approve that text there. So I would change that to say,
Recommend.
motion to recommend approval of ANX 2402 as conditioned based on the analysis and findings in the staff report, except that staff are directed to. So accept and then say, yeah, that staff are directed to. And then the first bullet point will say remove public works condition ANX A22. And then the next one will be
ANX.
Remove condition sub-6.d.
oh, I'm getting there, but
Okay, sorry.
before we
I
get
was
there,
skipping-
there should be
okay.
an ANX before that A22.
Okay.
Go. And then the next one should say modify condition sub 3C. C. Oh. To make explicit that the median shall conform to Oregon Fire Code. And then the last one, which I wrote on the fly, so let's make sure we get that right, is strike condition sub 6D and require for those 3 blocks identified in green on the staff report, page 30, exhibit sub 6D. Sorry.
What was the rest?
Identified in green on the staff report, page 30, exhibit sub 6D. The applicant to instead provide 1 tree for every 55 feet instead of code requirement for 1 tree per 30 feet. And then there is a very last piece that's just, and further direct staff to return with a final decision for the chair's signature.
Recommendation to City Council.
Oh, sorry, this is an annexation. My apologies. Yeah, never mind.
We just present this to the city council in a memo with our formal staff. And again, that's another hearing.
So I'm hoping that those conditions capture what was discussed in deliberation, but you're free to modify them, of course, as you see fit.
As soon as you're ready, if you share your screen, I'm happy to read the recommendation or happy to make the motion. Like to move to approve with modified conditions. I'd like to recommend the approval of the ANX 24-02 consolidated applications package with the conditions of approval as recommended in the staff report, except as staff are directed to remove Public Works condition ANX 24-02 A.22, to modify condition sub-3C to make explicit that the median will conform with Oregon Fire Code, and to strike condition sub-6D and require for those 3 blocks identified in green on the staff report, page 30, exhibit sub-6D, the applicant to instead provide 1 tree for every 25 feet instead of 1 tree for every 30 feet.
Okay, we have a motion. Do I have a second?
Second.
We have a motion and a second. I think I would like a roll call vote for this.
Sure. Commissioner Lassen,
Yes.
Commissioner May,
Yes.
Commissioner Berlin,
Yes.
Commissioner Bartel,
Yes,
Vice Chair Hernandez Mejia,
Yes,
Chair Ellsworth.
Yes. We have a motion carries. Thank you, gentlemen. Appreciate your time, and ma'am. All right, do we have any business from the commission? No, right? Any updates from staff?
I was just going to update you and remind you, you will be having a meeting in 2 weeks on the 24th. Quasi judicial item on, it's actually a modification to an approval that you recently completed, maybe a year ago, maybe even less, maybe 9 months ago or so. It's a gas station on the east side of Malala. They're making a modification to their approval. And because it modifies a condition, And it's significant enough that it has to come back through the process. You'll be looking at just that. This is the gas station on, across the north, yeah, on the other side of the street from Safeway, about 100 yards east. It hasn't been constructed yet, but we approved it. Just FYI, we're going through the budget process on our end, staff-wise. The budget committee meets, not for you to, you're all welcome to go read the budget if you would like. When it's out there. You're all getting a salary cut.
50% of the zero is still zero.
So that'll take up some time. And I just want to mention it's, you probably know this, but in terms of the planning and building, if you're curious, our funds come from different areas. Some of you know this. The building fund is funded exclusively through developer fees that come in. When builders come in, they pay fees for their permits, for their inspections, and all of that money goes in to support the entire building staff.
Are you
And
saying
everything.
it would be nicer that?
Not in the least. The other side, just if you're curious, if not, and a portion of some of the planner's salary comes from that because we work on a lot of building items. You know, we go out and do inspections. I met for about 3 hours today on just building issues. But the majority of the planning revenue really doesn't come from the applications that come in here. The revenue that we collect from applicants submitting site plan approvals, annexations, as an example, that application was probably $12,000 or something to go through the planning process. I can assure you that does not cover a tenth of the salaries and the staffing needs, because we also work on transportation system plans. We're working on all kinds of development code requirements, following legislation. Those things don't get paid for. But overall, I just want to let you know that the building side, things are actually really good in terms of the building fund, if you're curious about it.
Or the independent, I think, about the, I don't know, transportation or building of roads and stuff like, it's planned out for 500 years. Was that a typo?
I didn't read that article, but it came to me. That was ODOT's. That's how they're gonna, if you put it on a long enough glide plan, you'll get to it, right? It's like, I can't do it in 5 years, but if I say I'm doing it in 500, I can just commit, $8 to it every year and we'll get there. Yeah, that's essentially what they were getting around to, which I think is interesting. A lot of development going on in the city. We are not seeing a slowdown. We watch that very closely, right? Bizarre tariff things, economic, bizarre, who knows? Things come out of left field. They can all impact development. They can all impact real estate. They impact, I always tell the story that, and I won't talk about this happening, any developer, when they walk in to develop property, they're on like an 18-month, 2-year schedule, right? This applicant, say who was in here tonight, they're assuming 24 months from now, I need to be able to sell these homes at X price. And they got to figure out how much money they're going to spend doing every inch of that infrastructure, all the planning, the attorney fees, from now all the way to the end. They have to figure out, they don't know what construction costs are going to be, concrete costs, garage doors, roofing. That's a challenge. And the more uncertainty there is in the market for them, makes it extremely hard for them to say, great, I think I'll just go in for $20 million and I hope it works in 24 months. It's a lot. It's just the time frame for those things takes time. So short, my kind of summary of all that is we're in good shape. We in our city have not seen a slowdown in development. We haven't seen builders picking up and walking, which is encouraging. We continue to see applications like this coming in, taking up properties that are vacant and available and moving forward. So that's encouraging. I want to see development happening the right way, and that's what we tend to keep seeing.
And when is Amazon?
Ooh, great question. I have been told that they are shooting for a June 1st opening, and I can tell you we are working. That's what I spent my 3 hours today with, working on trying to get that opening to happen. There's a lot of pieces in there. It's the biggest building in Oregon. There's a lot of things to close out and button up. So yeah, they're going to open up like, this sounds odd. Their plan is they don't open like in phases. They don't like open a portion. It's like we're open for a few hours like a business can, and we're 1/3 staffed. they need to open. Trucks are coming, their doors are open. So they're going to gradually hire people over the next sort of 6-8 weeks as they bring them in, and they're going to open up and be kind of firing shortly after their doors open. So we're pretty encouraged about that. It'll get there. It's just a lot of details to get through it. And Chris is going to give you another update on something.
Yeah, so I am pleased to announce that I have a pleasant update. You will recall the last time we met, I updated you on the gas station project at Oregon Way and Highway 214. In that update, I mentioned that we had received a notice of intent to appeal, and that our position was that that appeal was untimely and therefore LUBA lacked jurisdiction. I just this morning received notice from the appellant's attorney that they agree, and so they are agreeing to a voluntary dismissal of that case. So
wow.
That project, once we get the final order from LUBA, which I don't think will take very long, maybe expect it next week, that project will be moving forward.
Oh, and I add that the applicant submitted for building permit today also.
They're wasting no time.
I appreciate everybody's thoughtfulness on these deliberations and on these processes. They're not always easy and sometimes they're quite challenging. I appreciate the work and the time that all of you put into this as well as staff. So thank you so much for being here this evening. With that, I would entertain a motion to adjourn.
I had a question I had mentioned to Chris, and he said he was gonna bring some things up. Colin?
Oh, what he was talking about. As I understand it, I think you had concerns about site distance. Is that right?
So my question was, and especially if, we need to go through the DO and just be able to maybe update or changes. Like, again, I know that there's already been several approvals and things construct, but I feel and believe that many of the corners where there's going to be crosswalks crossing streets where pedestrians are wanting to cross, some of them seem very dangerous because it's, the streets are going straight and there's cars parked right up to that crosswalk. And even if you're going 20, 25 is the limit, but even if you're going 20, there's someone who's just like either jogging or kind of running out. I feel like that's very dangerous because you can't really see them. And so my thinking was, and this is going to be very, so when you make like a circle so that it extends and you can kind of get people a little bit closer to where the road and the crosswalk are going to be, and also kind of serves as a bumper for cars to be parked a little bit further back and create more of that visibility. Is there a way or?
I understand what you're talking about. It's called a curb extension or bulb out. Yes. Okay. I wanted to preface by saying that there's a statute for this sort of thing. And so vehicles are not supposed to be parked within 20 feet of a crosswalk. But of course, does every driver in Oregon know that? Oh, no. And it's also confusing because I think people are used to Portland. Portland has a special exemption and statute, go figure, because their blocks are so small, you can park right up to the crosswalk, except in a few intersections now because people have complained. So some people may think they can legally park that close to an intersection, but in Woodburn, as in most of Oregon, they're not supposed to do that. So it's a matter of police enforcement and driver education. Although
Why don't you paint it in yellow? So people don't park there.
for that, I would have to defer to the Public Works Department.
Yeah,
Wouldn't it be red?
so I think there's a couple of things. And I could do this super fast. Would you mind pulling up an aerial? There's one spot I think of where I get a lot of comments, which is, I think it's Kirksey and Parr, which I think is an example. There's a lot of school children, a lot of school traffic comes out. And because there's an apartment building there, we get a lot of, I think that's Kirksey's and North South Road, that come in. So, of course, my and your real influence is over the WDO and the zoning code.
That's
right?
why I mentioned.
And That's the one I'm thinking of. There aren't cars there right now, but typically on that northbound Kirksey, you can kind of put your finger on it. When I drive in here, there are cars usually lined up right there. And it causes a real vision issue with all the pedestrian traffic. And there's a lot of kids there. There's a middle school and elementary school across the street right after traffic. I am not intimately familiar with like how far back you need to be from, say, a stop bar there where we would prohibit parking or the kind of things we do. I don't know of anything in our WDO that we would touch on. We do bulb outs a lot. Why don't you carve over to the ones going in Stacy? I don't know if they're in that on that map right there. Stacy Allison put in as an example. So some of the things we do, and I say some of these we just advocate for, might not be in the code, but we're happy to go in and spend more time calling them out. Let me show you a different example.
I think there's one right next to City Hall. That's where I'm.
Yeah, downtown definitely has them.
The downtown has them.
Oh, right. Downtown, we've got them everywhere. Right.
Yeah.
Do you know the reason we were able to do it? Because those are our streets downtown, and we redid that
we
probably
redid them.
6 years ago. And
Yeah.
I got to tell you, that was extremely contentious because we heard from, you were here. We had a lot of people who said, don't you dare do it because it's going to make impossible for any trucks to make turns. So like every other transportation issue, there's always this conflict between big trucks, fire trucks, as you heard earlier this evening, and pedestrians. It's the need to move traffic fast around turns and the need to slow it down so people can get through there safely. Those bulb outs, I mean, big picture, I'd say staff advocates for them often. Our public works department's gotten a lot better. When I started here, it was, you couldn't even dream. They were anti-landscaping and medians when I started here, right? Because they thought trees would hit them or cars would hit them and they don't want to maintain them. So this is an evolution. It's a hard thing to do. But these are important. I think those are really appreciated. I think it makes you slow down a lot when you go downtown. We put these in a few projects. There's some of these in Smith. I know we have them out at Stacy where they stick out, where we have a crosswalk, these bulb outs that we call them.
Yeah.
I'm not sure how to go into the WDO and add more, but I'm happy to inquire more about what the standards are and what we can do for some of these separations.
I mean, even if for a start, any place that is like a certain distance or path to whether it's like a park or something that is, you have especially children, I think it's maybe easier to advocate. And again, considering what we heard today, that is not left in this funky language that may seem a little ambiguous, but trying to direct it a little bit more. Yeah, I'm just always driving through certain areas that I've already spotted that I'm just worried and just slowed down because I'm always thinking someone's gonna pop out of there. Granted, the kid that ran was actually in a straight section where they just ran around the car and the parent like yelled at them, but it was like, oh. But still, that is definitely a concern. And then for anybody walking around and such, we've made the parks to try to make it, again, walkable, nice, appealing. But then when you have these certain things where it makes it very dangerous and cars are literally parking right up to some of those crosswalks.
We can find out that requirement, what that is. And I can ask about enforcement and public works and where they get involved, about striping, signing, et cetera, which leads to, can they provide tickets, et cetera. That's always where it starts.
Well, I think definitely the visual cues are helpful. I just think of these because it is very much a visual and like right in your kind of face to give all the clues necessary. But yeah.
Anybody else? All right, I'll entertain that motion then.
I make a motion that we adjourn.
I second. We have a motion, a second. All in favor, aye?
Aye.
All right. Meeting adjourned. Thank you all.